A very good afternoon to all our Lunch and Learn webinar watchers and all the people that have registered and all the people watching online. Today we will be discussing what types of orders can the court make and what type of orders can you appeal against when you're not happy with the outcome of your case. Hi, I'm Eugene Opperman. I'm a family law practitioner practicing specifically in the fields of maintenance, domestic violence, and children's law. And I'll be hosting the webinar today, but the presentation will be done by our article clerk, Erin O'Neill, which also compiled the handout for this webinar. So what we will be discussing today, or what Erin will be discussing today, is basically the discussion of Section 16 and the different types of orders that the presiding officer can make or that the maintenance magistrate can make, contemplating the question if a court can make an order for an amount of arrears except for the sections 26 and 31, as well as can a maintenance court make an order that the arrear amount must be written off? Now, that question we get quite often on our Facebook group. Can arrear maintenance be written off? We'll be discussing order that the maintenance can be done from a pension fund or from the benefits of any other provident fund. Is that allowed and how is it done? And then a discussion on orders by default and orders by consent. Lastly, we'll also be looking at how and when may an aggravated party appeal against any order made by a maintenance court, and a discussion of the orders that can be appealed against, and what orders are excluded and cannot be appealed. So you cannot, if you're unhappy about a certain order, you cannot follow an appeal procedure to have that overturned by a higher court. And then there will be a short explanation of the process of appeal and the documents and the time frames in terms of which these documents needs to be filed. That is in short what our webinar is all about today. Just on the side for some logistics, if you have registered on our website, www.lunchandlearn.org.za, you would have received a link today beforehand. And on that link, it would give you access to our web portal where you could watch the live stream like you're doing now, or you could watch on our social media platforms all over Facebook, LinkedIn, and as well as other media platforms, social media platforms. But most importantly, you would also have access to some pre-reading material, as well as a tab called the Resource and Templates tab. Now, under that tab, you will find a copy of the slides. You would also have a copy of the complete course handout, where we will be explaining or referring to during the course of this webinar. Also, what you will find is copies of all the documents that have been compiled, examples of affidavits and so forth that you could use, as well as the normal forms in order for appeal as well. That you could all find in the resource and templates folder. We will also include, if mention is made to any of the case law during the webinar, it will also be posted on that tab as well. But without further ado, I'm going to hand over to Erin that will take you through the presentation, and I'll be joining you right at the end for a short summary and a discussion of what orders the courts can make and how they can be appealed. Over to you, Erin.
Hello everyone, let's get right into today's Lunch and Learn. So the first point of discussion is Section 16 of the Maintenance Act and the different types of orders that a presiding officer of the maintenance court may make. So Section 16 obviously deals with the types of orders that the maintenance court is able to make. The pre-reading material extensively sets out the sections, so if you wish to follow what I'm speaking about, you can just consult your pre-reading material. It will have all of the sections word for word, so you can just follow in your pre-reading. So firstly, what types of orders can a court make? So the maintenance court is empowered to make various orders upon formal inquiry of the maintenance complaint. So it can make the following orders. A new maintenance order, so when you approach the maintenance court for the first time, this will be first-time maintenance applications. A maintenance order for lying-in expenses, which we will discuss in great depth in the next few slides. in order to substitute an existing order, which we discussed in a previous Lunch and Learn webinar. This was discussed quite extensively. An order against a person who is contractually liable to maintain, orders by consent, and orders by default. So these are the types of orders that a maintenance court can make. So let's go into each of them into a bit more detail. So you have your first time maintenance applications and line-in expenses. So what does this mean? So basically, when you go to court for the very first time, you will complete your J101. This has been discussed. And then you will apply for maintenance against someone who is legally liable to maintain their child financially. So this has been discussed, but just as a recap, you are only legally liable to maintain your biological child. So the person that is applying against you have to be legally liable to maintain that child. So the maintenance order is then granted against that person to make maintenance payments in accordance with the maintenance court order. So also, when you apply for maintenance for the first time, you can also apply for something called line-in expenses. So the applicant applies for this when the first maintenance application is made at court. So these are expenses which are incurred during pregnancy, during birth, and after birth. An example would be the hospital cost where you gave birth, or the doctor's appointments which you had to go to while you were still pregnant. These are all examples of line-in expenses. And these expenses must be claimed when the initial maintenance application is being instituted and not afterwards. So always remember that when you go to apply for maintenance for the first time, you are also entitled to apply for line-in expenses. Where there is already a maintenance order in force. So what type of order can the maintenance court make when there is already a maintenance order? So the maintenance court is able to make an order for the substitution and or discharge of the original maintenance order. So substitution, as we have discussed, is also known as variation. So either increasing or decreasing the amount of maintenance. That is considered a substitution of the original court order. And as we've discussed in the previous webinar, that new substituted order becomes the legally enforceable order and the other one falls away. Then you can also discharge a maintenance order, which just means to cancel the order. It will no longer have any effect or force against the respondent. And then if the original maintenance order is discharged, as I've said, it means that the order is no longer in force against the respondent. And it is also possible that the maintenance court may make no order. So that's also a possibility. Where there is non-compliance with the maintenance order, so where the respondent does not make timeous maintenance payments, that means that they are not complying with the maintenance court order. What will then happen? Well, Section 26 of the Maintenance Act deals with the enforcement of maintenance or other orders. So the maintenance court has the authority to make an order where the respondent has failed to make timeous maintenance payments in accordance with the maintenance order. So these are the enforcement remedies which could be used. These are the civil remedies in terms of Section 26. If you look at your pre-reading material, Section 26 is discussed. You can just follow there. But in summary, it is an execution against property, attachment of emoluments, and attachment of debt. So these were also discussed quite extensively in a previous webinar. We know execution against property. Attachment of emoluments is your point of departure. This is the garnishee order. And then attachment of debt is used as a last resort once you have attempted all the other remedies and they have been unsuccessful. So we will discuss that in detail with the next question, which is contemplating the question. If a court can make an order pertaining to an amount in arrears, except as provided for in sections 26 and 31. So we know that section 26 of the Maintenance Act, these are our civil remedies, which could be instituted to enforce a maintenance order against the respondent. and Section 31 deals with the criminal remedy, which is usually used as a last resort. So if the respondent is in arrears with the maintenance payments, there are a number of remedies available to the applicant to enforce the payment of the maintenance, claiming the arrear amount that is outstanding. So Section 26(1)(a) and (b) deals with the enforcement remedies. We have gone over them, but let's read the section. So it states that whenever any person against whom any maintenance order has been granted has failed to make any particular payment in accordance with that maintenance order, or against whom any order for the payment of a specified sum of money has been made under Section 16(1)(a)(ii), has failed to make such a payment, such order shall be enforceable in respect of any amount which that person has failed to pay, together with any interest. So basically what this means is that we have those 3 civil remedies which are used to enforce the payment of the outstanding arrear maintenance. As we've said, it's execution against property, which is provided for in Section 27, the attachment of emoluments, which is provided for in Section 28. This is also known as your garnishee order. This is the most commonly used enforcement remedy. And then the attachment of any debt, which is provided for in Section 30. Today's webinar we will be discussing the Section 30 attachment of debt in terms of a pension fund and benefits in a provident fund as well. So Section 31(1) deals with the criminal remedy, and that section reads that subject to the provisions of subsection 2, any person who fails to make any particular payment in accordance with the maintenance order shall be guilty of an offence and liable to a fine or to imprisonment for a period not exceeding 3 years, or to such imprisonment without the option of a fine. So this is our criminal remedy that could be used against the respondent for failing to make maintenance payments, which is a criminal offence. May a maintenance court make an order that the arrear amount must be written off? So as a point of departure, we know that maintenance is a legal right to which a child is entitled, and both parents have this obligation to financially support their child. This obligation falls onto both parents, not only the dad and not only the mom. And then failure to make these maintenance payments in accordance with a maintenance court order amounts to contempt of court and will be punishable either by a fine or by imprisonment not exceeding 3 years. So this is quite a harsh remedy, which is why it is used as a last resort. The applicant must first exhaust the civil remedies before attempting the criminal remedy. So the primary caregiver of the child, which is usually the applicant, can approach the maintenance office and lay a formal complaint to this effect. The primary caregiver must further show records of payments as well as non-payments, as it shows what amount is still owed or outstanding. And as is clear from our discussions, a maintenance court can never write off an amount of maintenance ever. So this is a legal right to which the child is entitled. So someone cannot apply to have the arrear maintenance cancelled. They will still be legally liable to pay that outstanding amount. So what orders can the maintenance court make? So in summary, as we've said, they can make an intra-maintenance order, a Section 16 maintenance order, line in expenses, substitution or variation of an existing maintenance order, a garnishee order, order by consent, or a default order. So the maintenance court can never write off an amount of arrear maintenance. So this is not something that can happen. You cannot apply for this. The only orders that the court can make are those which I have just mentioned, and not in writing off an arrear amount of maintenance. So the next question is, can a court make an order that maintenance must be deducted from a pension fund or from the benefits in a provident fund? So this is our attachment of debt civil remedy. So money which is contained in a pension fund is protected by law from any form of attachment by an order of court. So this just means that that money can't be attached. However, there are exceptions to this rule. Both the Maintenance Act and the Pension Funds Act allows an applicant to a maintenance case to claim maintenance from the pension fund of the respondent. So this is interesting. So the general rule is that in order of court, you cannot attach money in a pension fund. But then the Maintenance Act and the Pension Funds Act does make an exception where arrear amounts of maintenance can be claimed from a pension fund or the benefits of a provident fund. So if the respondent fails to make timely maintenance payments and falls into arrears, there are 3 civil remedies available to the applicant to enforce this original maintenance order. So these are the remedies that we have discussed. It is your execution against property and your attachment of emoluments, also known as your garnishee order. So the applicant must first exhaust those remedies, and if they prove to be unsuccessful, then only can the applicant apply for the attachment of debt remedy in terms of Section 30. So that remedy is only granted by the court once the other civil remedies have been exhausted. This just means that the other routes must have been unsuccessful, and then the respondent's employer has informed the court that the respondent has resigned. So he's no longer employed, so the garnishee order will no longer be successful. Then you can apply for the attachment of debt. So Section 30 of the Maintenance Act reads as follows and states that if either the order has remained unsatisfied for a period of 10 days from the day on which the amount became payable or the order was made, as the case may be, or the maintenance court suspends a warrant of execution under the Act, the maintenance court may make an order for the attachment of any debt owing then or in future to the person against whom the order is made. So this just brings back the point that we've said that the civil remedies, attachment of emoluments, and the execution against property, those routes must have first been followed and then have to be unsuccessful before an applicant can apply for the attachment of debt. So the maintenance investigator, once all the other civil remedies have been exhausted and they have now decided to apply for the attachment of debt, then the maintenance officer will find out whether the respondent has a pension fund. And if the respondent has a pension fund, the administrator of the pension fund will be served with a subpoena to release information in terms of that pension fund. So the information that should be released is the value of the fund and the benefit that is due to the respondent. So we have to ascertain how much money is in the pension fund that can be paid out to the applicant. So if it becomes clear that the information obtained, that the respondent does have a pension fund or a benefit due to them, the court will then order that the maintenance amount that is outstanding be deducted from that fund benefit. So in essence, it just means that arrear maintenance can be claimed from a pension fund or benefits in a provident fund. This is your attachment of debt remedy, as I've already said, that can only be used after the other 2 civil remedies have been exhausted and have proved to be unsuccessful. So now we will discuss the other orders that the court can make is a default order or a order by consent. So Section 17 of the Maintenance Act deals with orders by consent. So in terms of a consent order, the parties do not even have to be physically present at court. So this can be done without having to go to court. The consent form that is completed is the J214 form. And then the maintenance officer may request both parties to sign a written consent form and have that consent form made in order of court. So the agreement that is reached between the respondent and the applicant, that can be made the order of court. Therefore, they don't need to go to court physically. So the form looks like this. It is our J214. the consent and maintenance order in terms of Section 17, read with Section 16 of the Maintenance Act, which we have said is the types of orders that a court can make. And then a consent order is just one of those orders that the maintenance court is able to make. So where the parties do not reach an agreement, the matter will then be referred to court for a formal inquiry in terms of Section 10. So if an agreement is reached, that agreement is signed by the applicant and the respondent and can be made an order of court. But if agreement is not reached, it will be sent to a formal inquiry in terms of Section 10. So there have to be an agreement in terms of the amount of maintenance that should be paid, and then that agreement is signed and made an order of court. Section 18 of the Maintenance Act deals with orders by default. The pre-reading does contain the two sections, so if you want to follow, just look at your pre-reading material. I have set out the sections there. So where the respondent has been subpoenaed to come to court, or where the respondent has been warned by the court to appear at a later date, so they've been to court and then court asked them to come back at a later date, but they do not appear or they do not adhere to the subpoena to come to court, then the maintenance court will call upon the applicant to bring evidence in support of their claim. So what does this mean? So it just means that if the respondent has been subpoenaed to appear in court on a specific date because the applicant has applied for maintenance against them, if that respondent does not appear or does not adhere to the subpoena, so they just don't show up to the court date, then the applicant will appear in court. They will give their evidence regarding the amount of maintenance, the J101 form that was completed, all of their bank statements and slips. All of that evidence will be presented to the maintenance court in the absence of the respondent. So the respondent is not afforded an opportunity to state their case because they have not adhered to the subpoena and appeared in court. So then after hearing the evidence brought by the applicant, the court will make a default order in the absence of the respondent. So if you are the respondent, this is not something that you would want, because if you appear on your court date, you are able to give your evidence, and it might make the maintenance application go a bit more smooth. So always just come to your court dates. Don't ignore the subpoena. Don't ignore the court if they tell you to come on a specific date, because then they might just make a default order in your absence. The maintenance court also has the power to make an order as it deems appropriate in the circumstances, or make no order at all. So they can just, if they make no order that day, they would just postpone the court date until the respondent appears. So the maintenance officer, the sheriff, or the maintenance investigator must deliver the respondent a copy of the default order made in their absence. So if the maintenance court makes a default order, it is the duty of either the maintenance officer, the sheriff, or maintenance investigator to ensure that the respondent receives a copy of that default order, because that is legally enforceable against the respondent. So if a default order was made, the respondent is then allowed to apply for the variation or setting aside of that default order. The application for the variation or setting aside of that default order made in their absence must be made in the prescribed manner, and it must be made within 20 days after the day on which the respondent became aware of the default order. So the day on which the copy was served on them and they have now become aware of the fact that this default order was granted against them due to their failure to adhere to the subpoena or appear on the court date as provided for. So the respondent must provide the application with their notice of intention to bring such an application for the variation and or setting aside of the default order. The notice is then given to the applicant at least 14 days before the application is heard in court. So just to recap what we have just discussed, orders of default. So if you do not adhere to your subpoena, you do not appear in court, the court is empowered to make a default order in your absence. If you as the respondent if you are then unhappy with that default order, you are then able to apply for the variation or setting aside of that order. But this must be done within 20 days of becoming aware of that order. So basically as soon as possible. And then when you apply your application, a notice must be given to the applicant at least 14 days before it is heard in court. So you are, as the respondent, able to apply for the variation. So either the default order, you want the amount to be decreased, or you want that default order to be set aside. So you can do that. How and when may an aggravated party appeal against an order made by the maintenance court? So if you are unhappy with the maintenance order that was granted, how can you appeal this, or even are you even allowed to appeal this order? So if a party is not satisfied with the order made by the maintenance court, that party is allowed to appeal the maintenance order. So that is allowed. If you're unhappy or you're unsatisfied, you can appeal that order. You appeal the maintenance order to the higher court, which is the High Court. So this would be, for example, if you live in Cape Town, it would be the High Court of Cape Town. So the process that needs to be followed when appealing a maintenance court decision is set out in the Magistrates Court Act, as well as the Magistrates Court Rules and the High Court Rules, This is quite extensive, it's a very complicated process that's followed. So it is recommended that if you wish to appeal a maintenance court decision to the High Court, that you should consult with a legal representative. The process is complicated. I have set out the Magistrate Court Rules and the High Court Rules. I've set them out in the pre-reading material. If you wish to look at that, you would see that it is a complicated process and it is advisable to rather consult with an attorney. So Section 25(1) of the Maintenance Act confirms this process in terms of the High Court and Magistrate Court Rules. It reads that any person aggrieved by any order made by a maintenance court under this Act may, within such period and in such manner as may be prescribed, appeal against such order to the High Court having jurisdiction. So the High Court having jurisdiction just means, for example, if you live in the Western Cape, it would be the Cape Town High Court. If you live in Johannesburg, it would be the Johannesburg High Court, and etc. So you just appeal to the High Court that has jurisdiction where you live. So Section 25(4) sets out the orders which can be appealed and which orders are excluded from appeal. So in essence, what this means is that some orders that a maintenance court can make, so those orders that we have now discussed, some of them can appeal and some of them cannot be appealed. So which orders can be appealed? A discharge of a maintenance order can be appealed, and then also confirmation of the maintenance order, setting aside of the maintenance order, substitution or variation of a maintenance order, so where you have applied for an increase or decrease, this can be appealed, and any refusal to make such order, as well as refusal to make such provincial order, to make such order by default, or to make any provincial maintenance order under Section 16. So all of these orders are able to be appealed to a higher court. But then on the other hand, we have certain orders which cannot be appealed. So these are orders by consent. The logical reason why an order by consent cannot be appealed is obviously because the parties have reached consensus. So they have reached agreement on the amount of maintenance that should be paid and how it should be paid. So this order by consent is then legally enforceable. It cannot be appealed because there was consensus between the parties. And then also any provincial order referred to in Section 21(3)(a), and any order by default referred to in Section 18(2)(a). These are orders which cannot be appealed. And as I've said, the process that is followed for an appealing a maintenance court decision is set out in the magistrate court and high court rules. It is a complicated process, and as I've said, it's suggested that you make use of an attorney to assist you should you wish to appeal a decision of the maintenance court because it's so complicated. Rule 50 of the High Court deals with the process which needs to be followed when appealing a decision of the magistrate. So just for consistency, the appellant, this is the person who has now applied for the appeal. Because remember, in terms of the maintenance court order, we have the applicant and we have the respondent. So the applicant is the person who applied for the maintenance court order, and the respondent is the person against whom the maintenance order was granted. So either the applicant or the respondent can now appeal that order because they're either unhappy with the amount, they want it increased, decreased, etc. So if you now appeal that maintenance court order, you are now the appellant, and then the respondent is the person who did not apply for the appeal. So the appellant must note their intention to appeal the maintenance order. They must then, within 40 days from the date of noting their intention to appeal, they must apply in writing to the registrar of the High Court for a date that the appeal can be heard. So the appellant, the person applying for the appeal, they must, within 40 days of noting their intention to appeal the maintenance court order, they must apply in writing to the registrar, because he must then give you a court date on which the appeal could be heard. So at the time of applying for a court date, that person must furnish the registrar with their full residential and postal address, as well as their attorney's address if they are represented. So as I've said, it's important. The process is very complicated. It would be advisable to approach a legal representative to help you to understand all of the court rules. And so you will then supply the registrar with your attorney's address as well. So the appellant must also lodge 2 copies of the record with the registrar. So the record contains a correct and complete copy of all of the pleadings, evidence, and documents that are necessary for the appeal hearing. So this would, for example, include your original maintenance order that was granted, all the evidence that was submitted in terms of that maintenance order was also relevant. And then this must all be lodged in terms of your record. And then if the appellant fails to lodge an application for a court date, then the respondent may, before the lapse of 60 days, apply for the court date. So that's a mouthful. So just to recap, the appellant will note their intention that they wish to appeal the magistrate's decision in terms of the maintenance court. They note this intention, and then within 40 days, they apply in writing to the registrar to have a date on which the appeal can be heard in the High Court. So because it needs to be put on the roll to be heard, and the registrar will then furnish you with the court date. So just to go back a slide, so when you apply for your court date, so when applying in writing to the registrar of the High Court for a court date, you must also furnish that registrar with your full residential address and postal address, and then your attorney's address as well, because it is preferable if you are represented, and then also lodge 2 copies of the record. So we've said now, the record contains all of your pleadings. So everything that was used in terms of your maintenance court order to get to that point, all of those pleadings are contained in your record, as well as any evidence and documents necessary for the appeal. Your evidence that was given, for example, if it is a default court order, or you will use all the evidence that the applicant or the respondent gave, and then also any documents such as your identity documents or the birth certificates of the children. All of those documents are contained in your record. So this will obviously also become important for the appeal decision. And then if the appellant fails to apply in writing to the registrar for a court date, then the respondent can apply for the court date. So upon receipt of the application, the appeal will then be deemed duly prosecuted. And then upon receiving that application for a court date, the registrar must assign a date of hearing, and that date of hearing must at least be 40 days after receiving the application. So after receiving the application for the court date, 40 days after that, a court date must be afforded. And then the registrar must then give the appellant a written notice of the date of hearing, and that appellant will then deliver a notice of set down in writing to the clerk of the court from which the appeal originated. So that is basically the process that is followed when you apply for an appeal. So it's set out in the magistrate court rules and the high court rules. So just as a summary, I would just like to recap what we just did. So we discussed all of the orders that a maintenance court is able to make, and then what orders can be appealed to the higher court, which is our high court. So when you are doing a first-time maintenance application, something which is important to remember are your lying-in expenses. So the presiding officer will make an order against the person who is legally liable to maintain their children. And then that officer can also make an order for the payment of lying-in expenses. So we've said now the lying-in expenses are those expenses which a mother has incurred during pregnancy, during birth, and after birth. So these include your doctor's appointments. While you were still pregnant, you had to go to the doctor for your checkups. This can include those expenses as well as hospital expenses while you were giving birth. And then these expenses must be claimed when the initial maintenance application is being instituted in the maintenance court, and it cannot be claimed afterwards. So if you have already instituted a maintenance application, you cannot, as an afterthought, apply for lying-in expenses. These expenses must be claimed at the same time when the first maintenance application is being instituted. So lying-in expenses cannot be claimed as an afterthought. It must always be claimed when you do your first time maintenance application. So always keep that in mind. And then where there's already a maintenance order in force, as we've said, then so an order has already been granted against the respondent, you now have a maintenance order which is legally enforceable. Then the type of order that the court can make is either for the substitution or variation of the maintenance order. So you can apply for an increase or decrease, which we have discussed in a previous webinar quite extensively. But then the maintenance court is also able to discharge that original maintenance order. So to discharge the order means that it is cancelled. There is no longer a maintenance order in force against the respondent. And then it is also possible that on a specific court date that the court may not make an order, but they would just rather postpone the matter for further investigation or evidence to be given by either the respondent or by the applicant. So we know now that we have our first-time maintenance applications, lying-in expenses. Then when that order is granted, we now have a maintenance order in force. Then the maintenance court can make an order either substituting or variation of that original maintenance order. So the amount of maintenance can either be increased or decreased, or it can be discharged. So the original maintenance order can be discharged, meaning it is cancelled and will no longer have any effect against the respondent. So that is where you have your first time applications, where there's an order in force, and then the next one that we discussed was when there was non-compliance with the maintenance order. So where the respondent did not comply with the order, he did not make maintenance payments in accordance with that order. For example, he was supposed to pay on the 1st of June, but he was 20 days late with his payment. Then you are able to make use of your Section 26 remedies. So this was also discussed in a previous webinar. So as a recap, as we've said, those non-compliance, the civil remedies become available. These are Section 26 remedies, and this is your attachment of emolument, your garnishee order, which is instituted against the employer of the respondent, and then the maintenance payments are deducted from your salary. Then the execution against the property. This is where the sheriff comes to your house, makes an inventory of all your movable assets and the value of those assets, which are then sold at an auction, and that money is then paid to the applicant to make up for the outstanding amount of maintenance. And then we have our attachment of debt, which is used as a last resort once the other two civil remedies have been exhausted and proved to be unsuccessful. So as we've said, this brings us back to the topic where we have our pension fund and the benefits in a provident fund. So we have stated that the law states that money contained in a pension fund cannot be attached by a court order, but the exceptions are contained in the Maintenance Act as well as the Pension Funds Act, which states that it is possible that where a respondent is in arrears with his or her maintenance, the maintenance investigator will then try and find out if they have a pension fund, contact the administrator of that fund to release the information such as the value of the fund, how much money is in that fund. And if it becomes clear that there is a pension fund and a benefit due to the respondent, that arrear amount of maintenance can be deducted from the pension fund and paid to the applicant. But as we've said, this is used as a last resort. The first two civil remedies must first be exhausted and be unsuccessful. So that's a recap of the civil remedies where there is non-compliance. Brings us back to our arrear maintenance discussion. And then Section 31 deals with our criminal remedy. So it is a criminal offense, as we've said. It is a criminal offense not to make the payments in accordance with the maintenance court order. And this is confirmed in Section 31(1) of the Maintenance Act, which just states that the respondent will be in contempt of court if they do not make payments in accordance with the court order. And it means that they will be punished to a fine or to imprisonment not exceeding 3 years. So always remember contempt of court, but the criminal remedy is also used as a last resort. The most commonly used civil remedy is your attachment of emoluments, which is just the attachment of the salary, and then the maintenance payments will be deducted from the salary of the respondent. So that is the point of departure. We've discussed the pension funds and the provident fund. So it is possible for that to be attached. And then we have our orders by consent and our orders of default. So orders of consent, remember Section 17, your J214 form. If you and the respondent, as the applicant and the respondent, can come to an agreement on the amount of maintenance, you are fully in agreement, then you can just complete the consent form. This can be done in the maintenance officer's office. You do not have to go to court for this. You complete this form, you are in agreement, then that agreement is then made an order of court. But as we've said, if you are not in agreement, then it will be referred for a formal inquiry, so a Section 10 formal inquiry, because then we have to now determine the amount of maintenance and take into account the evidence of both the applicant and the respondent. But if there is agreement, this means that that agreement can be made an order of court. And then we have our orders of default, as we've said, Section 18 of our Maintenance Act, where the respondent has been subpoenaed to come to court, or the court told them to come to court on a later date, but they do not adhere thereto, they do not appear in court, the applicant is at court that day, but the respondent is nowhere to be found. It is absolutely possible for the maintenance court to have the applicant give evidence. So they will give their version of events, they will give the bank slips, the bank statements, everything necessary to determine the amount of maintenance. And then the maintenance court might make an order in the absence of the respondent. So Obviously, if you are the respondent, this is not nice because you did not have a chance to give your evidence. So always adhere to the court order. Just come to your court date, adhere to the subpoena, come to the court date, give your evidence. It might just work in your favor. But if you do not appear, it is absolutely possible for the maintenance court to make an order in your absence. As we've also said, as a recap, the respondent is able to apply for the variation or setting aside thereof. So a notice of this application must be given to the applicant so that they know that the order, a variation or setting aside of the order is being applied for by the respondent. So that's just a recap of default orders and consent orders. So then we discussed the appeal process. So how and when can someone appeal? How and when can someone appeal a maintenance court decision? So it is absolutely possible to appeal. As we've said, it's absolutely possible to appeal a maintenance court decision. The appeal will be heard by a higher court, which is the high court in the jurisdiction where you reside, for example. So if you live in Cape Town or the Western Cape, it would be the Cape Town High Court. If you live in Centurion, it would be the Pretoria High Court. You can appeal this to the High Court, and then you become the appellant who applies for the appeal. There are certain orders which can be appealed and certain orders which cannot be appealed that we discussed. And then the process for appeal is set out in the magistrate court and the high court rules. As we've said, complicated process. It is advisable to consult with an attorney to help you with this process. And then you must furnish your residential, your postal address, to the register of the High Court. You must apply for your court date. If the appellant fails to apply for the court date, the respondent can apply for the court date and furnish the record of your case to the registrar. This record is used in the appeal case because the judge will need this to determine an outcome, because they will look at all the pleadings, the evidence, and documents used by the maintenance court to determine whether the correct decision was made. And then a decision will be made. So it is possible to appeal as well. So that's just a summary of everything that we have discussed. So Rule 50 of the High Court Rules deals with the applications for an appeal. And that brings us to the end of today's webinar. It is basically a recap of some of the previous webinars that we have done. The Section 26 civil remedies. If you are unsure, you can always consult the previous Lunch and Learns. We have also discussed the variation of a maintenance order, which can be consulted in a previous Lunch and Learn as well. Thank you for listening to me today. It was so nice to discuss these orders and what can be appealed. I hope you enjoyed it. Thank you.
Right. Thank you so much, Erin, for that insightful presentation. Thank you so much. There's a couple of issues that I would like to stress and to reiterate and come back to. The one that one needs to understand in terms of the presentation today is that the magistrate court is a creature of statute. Maintenance court and the magistrate courts, those are all creatures of statute. Now, what is meant by that? That simply means that it has been enacted by law to operate as in court. So they do not have inherent jurisdiction like the High Court, but they have to operate within the boundaries of a said law and act. And in our instance, the Maintenance Act, they have to stay in the ambit thereof. And that's why it's important to know what type of orders the maintenance court may make, because they cannot make any order that they wish, and it's just a thumb suck, and they make an order as they feel like an order it seems fit. It is prescribed by an act, the Maintenance Act, and they have to stay within the boundaries of that act. And it's important for you as the viewers and the attendees out there to know what type of orders could be made. And it comes specifically about knowing what your rights are in terms of these orders, and what are your recourses if you are not satisfied with any of the orders that has been made. So that is vitally important, why you should know what type of orders the maintenance court may make. And it also speaks to the enforcement thereof, what to expect and how to deal with the processes, like we've been doing so with a series of webinars that we are hosting. One point that I would like to stress is the interim maintenance orders. And these orders are not very often applied for by either the maintenance officer or even the applicants in maintenance matters. Now, Section 10.6 speaks specifically to interim maintenance orders that you can apply for at any stage that a matter needs to be postponed. Section 10.6 clearly states that the procedure needs to be limited in time and duration with regards to postponement. So if you go to maintenance court and your case is being postponed day after day, week after week, then it's well within your rights to ask for a Section 10.6 interim maintenance order. Now, that basically means that it is an order made in the interim up until leading up to the finalization of your maintenance case, that you can apply for some relief, monetary relief, that the respondent pays that amount up until the stage that the application is finalized in court. So, yeah, Section 10.6, very important, the interim maintenance orders. Last thing that I would like to mention, which is I think also is very important, is to know that in the South African law, it works like cause and effect. If you have an order, there should be a way and there should be a means to counteract that. So if you have an application, for example, for a garnishee order or for a warrant of execution, if that is an order that the court made, then there should be, and there should always be, a way that could be countered or be terminated. So if there's an aggravated party, without going to appeal and the formal processes of the presiding officer not doing his job or being misguided by giving a certain order, there should be an order so that the respondent can come to court without going to appeal, to come to court to say, you know what, I want to terminate this application, or I need to terminate this order that has been made. For example, a garnishee order. It would be ridiculous if the legislator intended that in any instance where a garnishee order, for example, has been granted by the court, that it can only go on appeal and then it should be appealed and then overturned. So in every case like this where the court makes an order, there should be a process where the respondent could come to court and to say, but you know what, I really cannot afford a certain amount. And I need the garnishee order or the emolument attachment order to be stopped or to be varied. Same with the increases or the decreases of maintenance on the J107 or for the increase or the decrease. If you as the applicant can go to court for an increase for maintenance, and we've dealt this in previous webinars, there should also be a way for the respondent to come to court, to approach the court and to say, but I really cannot afford that. So it goes both ways. It could be used for and against, and there should always be two sides of the same coin, cause and effect. If the court can make an order for a certain thing, then there should also be a process of terminating that or bringing an application to court to vary that order instead of going through to appeal. That is basically on court orders and what you can expect. Yes, my name is Eugene Opperman. I'm a family law practitioner. I've been doing so for the past 23 years, specializing mostly in maintenance matters, domestic violence, as well as children's rights matters. It has been a pleasure hosting this for today, and thank you so much to our guest speaker, Erin O'Neill, a candidate attorney at Opperman's Incorporated. She's my right hand at the office when it comes to research and doing presentations as well. Thank you so much for joining us. We'll see you next week, same time, same place, for another episode of Lunch and Learn. Thank you so much for joining us.